Welcome, Shiv. It's always a problem when one has to introduce a person with enormous accomplishments. How long should an introduction be to do him justice and yet not delay his tryst with the audience? I'll do my best to find a via media. Mr. Shiv Kumar is a man of many parts. He is an advocate. He is a law graduate from Bangalore University, a partner in the full service firm of Murthy and Kumar. In this avatar, he has obviously had extensive practice in civil courts at Bangalore and High Court of Karnataka in all branches of civil law. Two, he is a teacher. He was in the faculty of BMS Law College and Bharatiya Vidya Bhavan, teaching constitutional law, business law, and press law. Three, he is a policy expert. He was a part of the consultative group on the Right to Information Act in Karnataka and the National Consultative Group on the Mental Health Act. He drafted the Elders Protection of Rights and Redressal of Grievances Bill, which is an exclusive legislation for senior citizens based on which the current Maintenance Act has been enacted, and so on. Four, he is a mediator. He is a certified mediator of the High Court of Karnataka since 2007, and he's had vast and varied experience in court annex mediation in the Bangalore Mediation Center, which is an initiative of the High Court of Karnataka. To equip him better for this role, he has completed several mediation training programs from Indian and US bodies in this field. He is a mediation trainer. To bring greater focus on mediation as a means of conflict resolution, he is a master trainer at the Bangalore Mediation Center since 2010 and has trained advocates and judges in mediation and conflict management. Now, there's a completely different side of him. He's a theater person. He has acted in several TV serials in Hindi and Kannada and has directed and acted in several English plays. Seventh, and most important to me, he is a very good friend. Shiv and I were very close friends when I was in college in Bangalore. There were months when there was not a day when we didn't meet up. Our homes were close to each other and we were involved in several activities together. We were rivals in intercollegiate debates and co-organizers of several youth service activities. We organized a model Lok Sabha, a model UN General Assembly session, not to forget, of course, the Toastmasters Club, where I believe he formed the roots of his amazing public speaking abilities, which you will see and hear today. I heard Shiv speaking on the importance of making a will a few days ago in another webinar, and I was so taken up by his knowledge and his eloquence that I felt this talk would benefit many of us. I present to you Mr. Shiv Kumar. Shiv.
Good evening, everybody. Let's try and get to the subject. It's a very morbid subject. It is something that doesn't actually generate happy thoughts. It generates thoughts of, as I said, death. It generates thoughts of property. And most important, it generates a thought of what's going to happen after my death. That's perhaps one of the most difficult questions to answer, and perhaps the most irrelevant question to answer, because after our deaths, I don't see why we should be concerned about what goes on. But we have our families, we have our children, we have our near and dear ones whom we love, whom we want to provide for. And therefore, it is being recognized, and I think it makes eminent sense to ensure that what you leave behind is a legacy and not a set of problems for your children and family to face. It's in this context that we constantly talk about making a will and so on. The opening slide will reveal to you the dilemma that most people are in, be it young or old. Will, is it a yes or a no? And if it is yes, why? If it is no, what is it that will happen? Let's look at it. Before we get into the actual drafting of the will and so on and so forth, there are certain things that society has constantly believed. Some of these beliefs are completely, in fact, all of these are completely logical. None of them have been validated anywhere around the world. There are no statistics to prove the belief of any of these. The first of these is the belief that only the aged and old should make a will, and most important, that they are the only ones entitled to make a will. Both these beliefs are completely irrational, because the time one should make a will is when you own some property. In the ultimate analysis, it is property that causes conflicts and disputes down the line after you. Therefore, the first myth that only the aged and old should make the wills is completely irrational. What follows from that, that only aged and old are entitled to make a will, is also incorrect. Anybody who has property over the age of 18 years is entitled to make a will. So let's get that clearly out of the way. The second belief is that a will is a bad omen and it accelerates death. I was working with the Elders Helpline for 15 years, where we were dealing with BPL, below the poverty line senior citizens. And I had got to believe that this belief was prevalent very largely in the economically weaker sections of society, or below the poverty line society. But as time went, I did have opportunity to talk to a lot of senior citizens in a lot of senior citizens associations, resident welfare associations, where they were reasonably pretty well educated, some of them holding very high positions in the government. And it came as a pretty rude shock to me to realize that this belief about will being a bad omen is prevalent across society. It is not necessarily restricted to one branch of society. Across society, the most educated people, including some of the very well-known scientists, believe that a will is a bad omen and it will accelerate death, and therefore I will not make a will unless it is absolutely necessary. The third belief is that a living will and a will are the same. This concept of a living will came about recently, about a year and a half ago, when the Supreme Court was dealing with the concept of euthanasia. They dealt with concepts like voluntary euthanasia, involuntary euthanasia, passive euthanasia, active euthanasia, and so on. And during the course of the judgment, they observed that in India, we do not have a concept of a living will. Though it is prevalent all over the world in several countries, it is not a concept that is prevalent here for the reason that a living will needs a statutory definition. It needs to be defined by statute. They, however, accepted the concept and they introduced what is called the Advanced Medical Directive. Consequently, a living will is a document under which you can specify what medical treatment you should get and you should not be given if you are in a life-threatening situation or you are in a terminal illness situation later on. That is all that a living will can do. Therefore, a will and a living will are two different things altogether. A living will relates to you are giving instructions as to how you should be medically treated, whereas a will relates to disposal of your assets and properties in the manner that you desire. This is the distinction. The last myth or the last belief that is widely prevalent is that when you make a will, it means that the assets that you have described in your will cannot be disposed of by you or dealt with by you during your lifetime. That is also not true. Any asset that you may mention in your will, as long as you are alive, you can deal with that property as in the manner that you may want to. Why is that? I'll give you a little story about when I joined King and Partridge as soon as I finished my LLB. There was a very old gentleman. He was a retired wing commander from the Air Force and he was a practicing lawyer at the time. And he used to deal with these morbid subjects of will and estates. So the very first brief that I got was to draft a will. I had no clue what it was, but nevertheless, we did some research and gave him a draft will. He looked at it, made some corrections, and he was also a notary public. He called the client signed it before him, and then the client left. And what this gentleman did was to give me that piece of paper and asked me to put it in a file, tie up the file, and put it away in a locker in the office. I had no courage to ask him why, but I did what I was expected to do and came back and stood in front of him and said, I've done it. And he looked at me and said, wait. So it was my first day at work and I understood it as saying that I should wait. And I did wait in front of him, waiting for further instructions. He looked up at me again and said, why are you waiting? I said, You asked me to wait. I said, no, 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 no. I'm not asking you to wait here. I am telling you that now that you have made the will and put away the file in a cupboard, you now wait for the person to die. That is what he meant. He said, as long as the person who is making the will is alive, the will is a lifeless, dead document. Once the person who makes a will dies, the will gets life. Therefore, this was the first lesson I learned. And since then, I have been making this comment to every group that I see. The will comes into operation only after your death. In other words, to use a very legal expression, it says, subject to your death, the will gets life. As long as you're alive, whether you're on life-saving devices, whether you're on a ventilator, whether you're on all kinds of tubes, since you are physically alive, then the will has no meaning or no life at all. Now let us look at what governs the will. The broad designation for all matters connected with wills and the properties is known as the law of succession. If there is a will that is validly made, it is called testate succession, in which case the directions that you have given in your will prevail. If, however, there is no will that has been made, it comes to be known as intestate succession. If a will exists, then the directions that are contained in the will be given effect to. Whereas if there is no will, then the personal law that is applicable to each of the persons who make the will apply. Now, when we talk about different personal laws, we talk about a separate law for Hindus, a separate law for Christians, separate law for Muslims, separate law for Parsis, and so on. Each one of them is governed by a statutory provision. And if you therefore do not make a will, there is no question of imposing or ensuring that the directions that you had in mind will be given effect to, because they are not contained in a will. The personal law applicable will automatically take over, and whether you like it or not, the assets that you have will go to those persons, whether you like it or not. That is the difference between intestate and testate succession. Now, when we talk about wills, we necessarily talk about property or assets. Assets are of two kinds. One is immovable property and the other is movable property. Now, immovable property comprises land. It could even be agricultural land. It could be a site or sites, as the case may be. It could be an apartment or apartments. It could be an independent house. It could also include an under construction apartment. It is not necessary that the apartment should have been constructed completely, or that an occupancy certificate or other legal formalities should be available. Anything that is under construction, but which should come to you maybe 4 years later, 5 years later, is also considered to be an asset or removable property that can be disposed of. We also have something known as leasehold rights. Suppose you own a building and you leased it out to 10 tenants. You can actually in your will say who will actually succeed to the rights of you as a lessor or owner of the property. If you are, however, a lessee in a building, suppose you have taken a building on lease or a shop on lease or a building on lease or an office space on lease, it is possible for you to bequeath that right also under a will to any person you wish. So the broad spectrum of immovable property covers all these 6 items that I have displayed for you on the screen. If you do have any questions, please do feel free to interrupt. There are some questions which we will answer at the end. But in the meanwhile, if there are any doubts or questions you would wish to ask, please do interfere, because andragogy, adult learning, one of the characteristics of andragogy is that when that question occurs, if it is not answered, it loses significance and relevance. So please don't bother about, it's not interference, it is not causing me any disturbance. Please do feel free to raise your hand, or Raghav is the host. You can always give him send a message to him on chat, and he will disturb me or call me and stop me. Okay? Yep. I can't hear you. I can't hear you.
You can't? I don't know. Maybe.
Sorry, go ahead, Shiv. We
No, I
keep track.
can't hear the. I can't hear the question.
Is there a question?
Yeah,
Somebody's.
what happens if you become medically, I mean, you're alive, but then medically in such a condition, either mentally unsound or you have, you're in coma or you have in some kind of a very serious bedridden kind of a condition.
I think that question you will get an answer to in the next 2 slides.
Okay.
Okay.
You-
Okay.
In fact, having seen Shiv's presentation before, I think practically all your questions will be answered. In that sense, I think it's best to hold your question till the end because there's everything that I could think of
No, it
is
doesn't
got
matter.
covered. I think
Every participant has a fundamental right of speech under the Constitution, so I think that no issues. Okay.
not when Raghav is the director. Let's go on.
All right. Now, since we've talked about immovable property, we now talk about movables. What constitute movables? It's a very wide list. It comprises bank accounts, your fixed deposits and term deposits, lockers, corporate deposits, mutual funds, shares, debentures, demat accounts, monies that are due to you from somebody, jewelry, personal effects, furniture, gas and telephone connections, the vehicles you may own, household goods and consumer durables, email passwords, stored data on your hard disks, copyright you may have in some of the books or materials you've published, your heirlooms that you may possess, artifacts, curios, and pets also included. In fact, there are wills where a large extent of the property, both movable and immovable, is given away to a pet for taking care of a dog or a cat or a house for cats and dogs. Therefore, all these things that you see in under this heading of movables will constitute movable property. It simply means that any of these you are capable and entitled under the law to give to any person you want or not to give to person whom you don't want. Now let us go back to the earlier slide of intestate succession. If you have not made a will and it results in intestate succession, the law of succession under Hindu law, for example, will begin to operate. And your wife and your children and your mother, if you're a male, all of them will get an equal shares in all these properties that you mentioned here. You may not want that to happen. If you do not want that to happen, then the only answer available to you, the only remedy available to you is to make a will. All right. Now the question is, who can make a will? Any person over age of 18 years can make a will. He must be a sound state of body and mind. This is the crucial sine qua non of making a will. Any person who makes a will must be in a sound state of body and mind. He must be healthy. He must be in a state of mind where he understands the consequences of the act that he is doing. And more important, understand the act itself that is being done. If a person, for example, believes that he is signing a receipt or he is creating a mortgage in favor of a bank, but in fact is signing a will, then it will not be a valid will because he has not understood the consequences of that act. Therefore, the critical factor, irrespective of who is making the will, is are you or are you not in a sound state of body and mind? This leads us to the earlier question that was asked. What happens if a person is medically sick? He's sick and he's in bed. He may be physically not in a state of body, happy state of health. But the question is, in spite of that state of health, was the person in a state of mind where he understood what he was doing, as also the consequences of what he was doing? This is why we make it very clear. We repeatedly tell people, particularly senior citizens, please do not wait until you reach a nursing home or a hospital to make a will. Because the presumption when you are in a nursing home or a hospital being attended to, worse if you are in an ICU, the presumption will be that you were neither in a sound state of body nor in a sound state of mind. And therefore, the burden will be on you to show that you actually did understand what was being done and what was not being done. Therefore, even if you are not able to move your body, if let's say you have suffered a stroke, but as long as your mind is agile and you're able to understand the fact that you are signing a will and to whom you are giving the property, it will be deemed to be valid will. And as a byproduct of this, if you unfortunately are in a hospital and you want to make a will, it is best done by getting the two doctors there, one or two doctors attending upon you, to certify that you were in a sound state of mind when you actually made this will. So please remember, it doesn't matter what state of physical pain you are in, but the question is, you must be in a sound state of mind. Having said that, if your state of body is so bad, the pain is so bad that it affects the working of your mind, then you are not considered to be in a fit state of mind or a sound state of mind. These are interrelated, these are interdependent. A non-sound state of body by itself is not bad, but a non-applicable mind, a mind that does not comprehend what you're doing, is a no-no, and the will become completely invalid. There is another common belief that married women cannot dispose of their own property. This is born out of our belief, largely in our society, that women are incapable of handling their own affairs. This is particularly relevant in the economically weaker sections of society and a large middle-class society. As I said, Raga will hear this again, but I keep saying this. A 70-year-old man and a 60-year-old woman who've been married for 40 years or 50 years, if she has looked after the husband and run the household for 45, 50 years of her life and managed the children and the education and the household, what is it that comes in the way, or what is it that leads the man to believe that she is not capable of looking after her own property? It's completely baseless, it is completely indefensible to say that. But the law says otherwise. The law says even if you are married, if you have independent property of your own, you are absolutely free to dispose of your property the way you want to by making a will. There is no restriction on that at all. Next question. Can a deaf person or a dumb person or a mute person, can they make a will? The answer is yes, absolutely. Again, provided they understand what they're doing. You can use sign language, you can write to them and explain to them, but mentally they must be certain that they are actually signing a will and not any other document, and that they have understood the consequences of that action. Next question, insane person. The law says an insane person during lucid intervals, when he is not in that insane state, is also capable of making a will. This has to be distinguished from mental retardation. A mental retardation is an arrested development of cognitive abilities. And therefore, a mentally retarded person may not be able to make a will because the mind is not capable of understanding or comprehending the results of the action. But an insane person during lucid intervals is capable of making a valid will. Now we come to the most interesting one on a Saturday evening, an intoxicated person. So the answer is, on a 31st night, for God's sake, don't make a will. Stay away from it. Give it 2 days, finish with your hangover and make your wills on the 2nd or 3rd of the next year, but certainly not on the 31st night, because if you're intoxicated and you are able to prove that you are unable to understand what you did, the will itself becomes invalid. Then the question is, why do you want to make a will? What is it that is so important? The clear advantages of making a will is that it will ensure disposal or distribution of your assets as you wish. This is to be understood in the context of intestate succession. If there is intestate succession, the property goes to people you may not want it to go to. You may have a couple of children, one of whom may have married outside the caste, and therefore you would want to disinherit that person. These are common examples that happen every day in life. This is nothing new. I mean, I'm not giving you, this is not imagination working. This is live examples working. These people call it ring fencing their property. The parents want to ring fence their property because the daughter or the son has married outside the caste and they do not wish that their assets go to somebody who belongs to a different caste. This is the rightness or wrongness of this is not something that we will sit in judgment over. It's an independent thought and independent decision that people make. So if you want to ensure that your assets are distributed in the manner you want, then the answer lies in making a will. It prevents persons you wish to disinherit from claiming a share. Let's suppose your son has become, or one of your children, or one of the persons you want to give your property to has become a drug addict, or he has become a petty criminal, or he has become a undesirable element of society, and you do not wish to give him property, then the answer lies only in making a will. Because if you do not, then whether you like it or not, that person will inherit some portion of your property because it becomes intestate succession. As I said, it is also a guarantee against application of personal law. If you do not want the law of succession to apply, then you do make a will. It enables charitable bequests. As we grow older, we get spiritual is the comment that a number of people make. We also get spiritual, but we get spiritual with a glass of whiskey probably, and that's not the kind of spirits we're looking at. If you want to make a bequest to your Ramakrishna ashram, or you want to make it to a temple, or you want to make it to some other charitable institution, you can do so only under a will. If you do not make a will, then these charitable institutions who would otherwise have got a bequest from you do not fall under the category of heirs under the personal law. Therefore, they will not be entitled to get any share or portion of your property unless your children or the person to whom you are giving away the property remembers that you had made a request or you were interested in giving away a certain portion of your property to an institution, and in his or goodness gives away that property. Otherwise, there is no entitlement of a charitable institution to property unless you bequeath it under a will. It also avoids future disputes, litigation, and consequent acrimony amongst family members. We every day in our professional life deal with cases where wills are challenged or where there is no will. Typically, the daughter gets married and leaves home and goes and stays with the husband. The parents are staying with the son, rightly or wrongly, but the property belongs to the senior citizen, to the father. The father gives away the entire property to the son. Now, this is the typical putra moha, we call it in our Hindu philosophy, and that the son is the ultimate guarantee for senior citizens. He gives away that property to the son. How does the dispute arise? The daughter begins to claim a right. And on what basis would she claim a right? On the basis that the will that was not made while he was in a sound state of mind, or that the son influenced the father, coerced him, forced him to make this will, giving away everything to him. And that litigation not only leads to acrimony amongst family members, but it leads to phenomenal amount of litigation. Believe me, it becomes a lawyer's paradise. A situation like that will ensure the future well-being of at least 4 lawyers. Now, that's a very charitable object. If that is your intention in doing so, there are other ways of giving that money to a lawyer. Why get into litigation? Litigation apart, it results in acrimony amongst family members. What we have seen in 35 years, 40 years of my working with senior citizens is that once there is an issue relating to property, families get divided, which leads to the next generation also getting divided. So the young kids, 5-year-olds, 6-year-olds, 7-year-olds are taught not to mix with the brother's children because they are bad people. So the whole fabric of family gets completely destroyed, all because it is property. And please remember, the property that you gift away or you bequeath to your children or whomever you wish to give comes to those people free of cost. It is free property. They have not earned that property. They have not put in a pie to earn that property. And therefore, the principle, what comes free, why should I refuse? When I'm getting something free, In Kannada, we say it is pukat. I don't know how many of you understand Kannada, but it is something that comes free. So why should I give up even one portion of it? These factors contribute to litigation and acrimony among destruction of family. It also ensures protection and safety of your spouse, your loved ones' independence. Now, we have seen lots and lots of cases in our professional life where, without making a will, the man dies. The moment that happens, the children get a right in that property due to intestate succession. The victim in this is the spouse, the wife. Because the children are in control of that property, or at least a major portion of the property, your spouse gets thrown out of that house, has no means of livelihood, becomes dependent upon some other people to lead her normal life. If you want to avoid that, the only answer again is to make a will. There is another class of people who are within your family. It may be dependents. It may be a mentally challenged person. It may be a physically challenged person, or it may be a differently enabled person, as we call them. Or he may be mild MR, that is mental retardation, or he may have mental illness. And you may want to ensure that that person receives health care and is looked after the way he should be looked after. If you do not make a will, I'm afraid there is no guarantee that these dependents or these loved ones will be taken care of, because you have no way after your death of ensuring that your wishes are given effect to. Now, what is a will? A will is what is called a testamentary document, which directs distribution and disposal of your assets. This is usually contradictory to a non-testamentary document. A non-testamentary document is something like your lease deeds, your sale deeds, your gift deeds that you make. Contrast to that is a testamentary document. Now, these testamentary documents like sale deeds and gift deeds take effect on the date you make them. That means it takes effect immediately. A testamentary document, which is a will come into effect only after death of the person. As I said earlier, either the will live or the person will live. So the difference in testamentary and non-testamentary document is a non-testamentary document divests you of your properties and right immediately. The moment you make a gift deed and sign it and register with the sub-registrar, you have lost control over that property. You are no longer owner of that property. Whereas if you make a will, that property will pass only on the death of the person who is making the will. A will is a document that is enforceable at law, provided it is validly made, provided it is made without undue influence and force or fraud of other people. It is enforceable at law. The law recognizes wills and will give effect to the directions of the deceased person, irrespective of what other family members may say or what society may say. Your members of your family may feel that giving away all the properties to one person is unfair, but if under that will, which is a validly made will, that is what you have desired, the law will give effect to it, whether other people like it or not. Alterations in will are permitted. You can make as many alterations as you want. Either you can make it by rewriting the will, or you can make what is called a codicil, which is an amendment document. And the rule of law is that the last will, chronologically made, will be the one that will prevail. Similarly, if in the first paragraph of your will you have said that my asset, my house must go to my daughter, and in the last clause you have forgotten what you have said earlier, in the last clause you say it shall go to my son, the last clause will prevail and the daughter will be deprived of the property, because that is a chronology. The last one is what is required. This is another reason why we constantly tell people, please make your will when you're in a sound state of mind. In the first clause, you have said son. By the time you reach the last clause, you have said daughter. Somewhere in the middle, you may have said wife. To avoid these confusions, please make a will when you're in a sound state of mind. Registration is not compulsory, but we advise that it be registered only for one reason. The society is becoming horrible today. What comes free will be fought for. What the law requires is that you have made a will when you're in a fit state of mind and body, and having known the consequences of your action. If you register the will before a sub-registrar's office, it is considered prima facie proof that you are in a sound state of mind, that you have actually appeared before the sub-registrar and have executed the document voluntarily and willingly. That is prima facie proof of a valid execution of a document. Therefore, we advise registration. We also advise registration because currently every statutory authority like the corporations or the municipal corporations or the banks insist that the will be registered. So if you have given away your property to one of your children and it's an unregistered will, the corporation will insist that you get an affidavit from the other heirs saying that they have no objection to registering the property in the name of your son or daughter. Society has it has turned around that way, where every transaction, every suspect, and therefore to provide for future safety, we advise registration. Now, this will must be signed by the testator. The person who makes the will is known as the testator. Either he can sign it, or he can put his thumb impression on it, or he can put any mark that is clearly identifiable as belonging to him. You can put a swastik, you can put an Om, you can put Ganesha's, you draw Ganesha's idol, no problem. But it must be identifiable and traceable to you. It can be done. Or if you're not in a position to move your hand or your finger, but you're in a mental state of mind, you can ask somebody else to sign the will on your behalf and record there that this has been signed under direction of the testator. This would answer the earlier question also. If you're in a medically unfit state where you can't even move your hand, but you're mentally extremely alert and know what you're doing, it is possible that your wife or son or children or whoever can sign it on your behalf, provided you make an endorsement there that this has been signed under my directions by so-and-so. There is no concept of an oral will. Every will has to be in writing. There is no such thing as an oral will at all. This will must be signed by 2 or more witnesses. They are also known as attestors. These witnesses must see you signing that will. Technically, they must sign in your presence because they must see you signing the will. But it is not necessary, but both the witnesses must sign at the same time. They can sign at different times, but the important thing is that they must see you signing it. Now, the important thing to remember is the witness cannot be a beneficiary under the will. If you are giving away your property to your son, he cannot sign the will as a witness. Whoever you are giving your property to cannot appear as a witness in the will. Then, a witness can be an executor to the will. An executor is a person who is appointed under the will by you, in whom you have trust and faith, to execute the will, to carry out the directions that you have given under the will. But it is not compulsory. The same job can be done by any of the family members or any person to whom you have given the property. The executor steps into the shoes of the deceased. His job will be to collect all the assets of the deceased and dispose it off in the manner you have directed. Now, a will is automatically revoked upon marriage. You may have made a will when you're 25. The moment you get married at 27, that will automatically ceases. You'll have to make a fresh will. I'm not sure whether that is a contingency that will arise in the age group that we are, but it may. There's nothing wrong in it. If it does, please remember to make another will. What is important is the intentions of the testator. The words that you use, we are not worried about what words you use, as long as the words are clear, unambiguous, and in no uncertain terms convey the intentions that you had in mind. Suppose you were to make a will and say, I am going to give the house that I'm residing in to my son. English language perfect. But the question arises, where were you residing? Suppose you have 2 houses. Then the question arises, which is the house that is being talked about? The very common example that we are taught in law colleges is, I want to sell my horse to you. The question is, which horse? I have half a dozen horses. There's black, there's white, there's gray, there's brown. So the words are important to the extent that they must convey the intentions of the testator completely unambiguously and without leaving any doubt for interpretation of the word. Suppose you say a word, I give my house number bearing number so and so to my child who loves me most. How would you even understand this language? Now there is a question about who loves you most, your daughter or your son. This is not unambiguous language. This is rooted in conflict. And I said these are lawyers' paradise. That is what will happen. Next, the will must relate to the assets that are owned by the testator. You cannot will away the Rashtrapati Bhavan to anybody else. You can't will away the any other property that you don't own to somebody unless you actually own it. But let's say you and your wife both own properties jointly. Can you give away the entire property to somebody under a will? The answer is no. Because when we talk about joint ownership under the law, both are equal owners. If a sale deed is in the name of you and your wife, or you and your son, or you and your daughter, or your siblings, the names that appear there are joint owners, which means they own 50% each. Having said that, suppose you and your wife buy property together and you have contributed 80% of the funds and your wife has contributed only 20% of the funds, then it is possible to mention in the sale deed that 80% of the property will belong to me and 20% will belong to my wife. But if you have not said so, then the law will presume that it is 50-50 ownership and you will be able to dispose of only your share of the property. The next question that most people ask is, what happens to property that I might acquire after making the will? Two concepts here. One, that a will apply to assets that are existing on the date of your death. In respect of assets that you may acquire future, you can either make a separate will, or we provide for what is called a residuary clause. It says that I will give my properties that I may acquire hereafter, namely the properties that I may die possessed of, to so and so person. So it is not necessary that you make a fresh will each time. It is possible to convey whatever you want to in the will that you may make now. Now, it is also possible, if you have 10 properties, it is also permissible in law to make 10 different wills in respect of each property. That's also allowed. Now, why is that assuming importance in today's world? You may be a very wealthy person, and therefore all your assets are recorded in that will. Now, if your son wants to sell one of the properties that you have gifted to him or given away to him, the purchaser will ask for what is called as title documents. He will ask for documents to show how did you acquire ownership. And the answer to that will be, I have acquired it through this will. He will ask for a copy of the will. Now, once I give a copy of the will, it records not only this particular property, but it records a complete detail of all the assets that I own and all the properties that I own, including my financials. Now, this becomes very tricky for high worth net individuals, HNIs as we call them. They do not want to disclose it. Therefore, the answer to that lies in make a will separately for each item of immovable property. Very simple, can be done. Now, as I said, in case of two inconsistent clauses in the will, the last one will apply. If you want to make a bequest to a religible charitable institution, you have to make that will at least 12 months prior to death. Now, the answer again lies is make a separate will for charitable causes and leave it alone and say, this is what I would like given to either Ramakrishna Ashram or to the Buddhist colony, or whatever your choice is. Make a separate will in respect of that 12 months before you die. In other words, it works the other way. You don't know when you will die. Therefore, make it now. If it is 14 months, it doesn't matter. At least you have taken precautions to do that. Then there is something known as contingent bequest. It's like saying, if on the date of my death, I have owned a Mercedes car, then this property will go to my son. It is contingent upon the happening of a certain event. If that event does not happen, then the question of bequest does not arise. There is also something known as conditional bequest. Suppose you make a bequest and say, I give this property to my son, provided he gets married by the time he is 30 years old. Allowed in law, perfectly allowed in law. But the danger there is he might get a wife who looks at the property and not him, and your property will therefore go elsewhere, and your object is not served. But that is permitted. Now, there is something known as the concept of vesting in law. This says that the moment a person who has made a will dies, that moment the persons to whom you have given your property under the will become owners. Nothing else need be done in law. Death occurs, half a second later, all the other persons to whom you have given the will become owners. This is called the theory of vesting. So there is no gap, there is no vacuum in law. One person dies, somebody else becomes owner. You have not made a will. The moment you die, all the heirs that are specified in your personal law automatically have become owners under the law. Now, the next question, simultaneous death. What happens if all of us are traveling together in an aircraft, or you're traveling in a road on a happy holiday, and all of you die because of an accident? The law says we will try and determine who died first. We'll talk about intestate succession and testate succession both together, doesn't matter. If the husband had died first, then the provisions contained in the will of the husband will come into effect. But if the wife has died first, then what is contained in the will of the wife will come into effect. Now, what happens if you're not able to determine who died first and who did not die first? As it happens in several air crashes, it is not possible to figure out what is the time of death. Then what happens? Then we get into what is called probability. We look at who could have and who could not have. So we artificially fix a time where the first one is at this time, the second one is at this time, and so on and so forth. Therefore, in the will, the provision that we make is, it reads like this: in the event of both of us driving, all of us dying simultaneously, then without reference to the sequence or time of death, the properties will go to so and so. So make a provision there and say it doesn't matter who died first, who didn't die second, but irrespective of who died first and second, the fact that all of us have died together, the property will go to so and so. The last kind of wills is called mutual wills. This is a very simple form of making a will where the husband says that all my properties go to my wife, and the wife says all my property goes to my husband. This saves you the bother of making two wills, and mutual wills are acceptable in law. This, I think, will answer one of the questions that has come. Now, I think I have another 7 minutes. Is that right, Raghav?
You're free to go ahead, I'm sure. Let's cover the subject.
You don't know, Raghav, you don't know what you're letting yourself in for when you give a lawyer a captive audience and a mic, and you really don't know what you're getting yourself.
You must remember, I have control over your mic. I can switch it off anytime.
All right, good. So let's go about this a little more about the wills. As I said, an appointing executor is not compulsory. There is something known as probate. A probate is an order given by a court which confirms that the will is valid, that the bequests that have been made under the will are valid bequests, and therefore that the directions given by the testator must be given effect to. It is a court order. But under the law, it used to be compulsory. Today, it is no longer compulsory. It is not necessary to probate a will. Typically, if you don't have a registered will, people ask for probate. If you have a registered will, it is prima facie proof that you have appeared before the registrar and have validly executed that will. But let's suppose you do not have a registered will and you want to claim ownership of the property that you have given to somebody. The son wants to claim it. It is possible that the bank or the financial institutions or the corporation may ask for probate. Probate is an expensive affair. It not only requires lawyer services, but it also requires payment of a certain prescribed court fee before you get that, the probate. There is no stamp paper required for a will. It can be on plain paper. The will can be written in handwriting of the person who is making the will. And if you are writing the will in your own handwriting, it is not even compulsory to have two witnesses to sign that will. But if you are writing the will when you're 70 years old, then there is every possibility that your handwriting 10 years ago or 5 years ago would be different from the handwriting that you've got now. That is yet another ground for disputing the will, saying that this is not his handwriting at all, and therefore the will is invalid. Therefore, in the absence of a will, it goes to intestate succession, and consequently, all the heirs mentioned under the Hindu Succession Act or the personal law will be entitled to a share. Therefore, if you have an extremely good handwriting, which can be matched with your handwriting some 20 years ago or 10 years ago, please go ahead and write it. Otherwise, please go through the process of typing it and having it registered. Now, under a will, if I own property and I give away that property to my wife or to my children, I cannot control the manner in which my wife or my children deal with the property. Once that property is given away under a will to somebody, that person becomes absolute owner of that property with complete power, absolute unconditional power to deal with the property of his or her choice. You cannot create a problem by saying that you will not sell it or that you will not mortgage it. Once you vest absolute ownership in the person, maybe your son, maybe your daughter, whomever it be, that person is entitled to deal with the property in any manner of his choice. So what is the process? Please make a list of all your removable and movable properties on one column. Second, make a list of all your movable properties, that is bank accounts, mutual funds, shares, debentures, deposits, etc. Now, before you do that, please ensure that insofar as your bank accounts and movable properties and shares and debentures are concerned, nominations have been made. There is a very common misconception that a nomination equals a will. It is not. If there is a nomination that exists in your fixed deposit receipt with the bank and you have nominated one of your family members, on your death, the bank is completely discharged and protected in law if that amount is paid to the nominee. That is all that happens. It is a protection to the bank. But if you have not made a will and the bank gives that money to the nominee, all other children and your wife will get a share in that property, in that deposit, notwithstanding that the bank has given the money to the nominee. The nominee only acts as a trustee, holds that amount for and on behalf of all the legal heirs unless there is a will. If you have made the nomination in favor of your son and in your will also you say this deposit will go to my son, there is no issue at all. But title or ownership to that deposit is not the same thing as nomination. To put it very simply, a will overrides or supersedes a nomination. A nomination is protection to the bank and it does not confer title or ownership on other legal heirs. The next thing you do is to determine the beneficiaries to whom you would like to give it. Most important, more important, determine the list whom you don't want to give it to. That's important. Giving it to is very easy. Whom you don't want to give it to, please make a list. And then item number 4 may be a little dicey for you guys because you may not want to consult an advocate for drafting. But our suggestion is please do go to a competent professional. It doesn't matter if you have to pay a fee to that person. The reason why you go to a professional is that in today's context of law and the interpretations of law, in a testamentary document like a will, we would like to avoid words which are capable of multiple interpretations, like the one I gave you. I give my property to my child or to one of my children who loves me most. It becomes interpretation. Therefore, do get to a professional who will help you in drafting, in understanding what your intentions are, and then putting it down on paper. Right. Now, what can you do with the movable property? You can give it away to one child completely. You can give it to all children in equal shares if you want. You can give it to all children in different proportions if you want. 10% to somebody, 30% to somebody, 40% to somebody. But please remember, if you have only one house which is incapable of being divided into 4 parts, then you are creating a greater problem for your children when you give it in percentages. It's a different matter if you have 5 or 6 or 10 houses, one house to each person. But if one house is to be distributed and bequeathed in terms of percentages, you are inviting trouble. Therefore, though it is legally and technically possible in law, try and avoid giving away immovable property in percentages. You can give it entirely to your spouse. Very rarely does this happen. In the number of wills that I have drafted, it is probably 2%, 3%, or 4% where property is given entirely to the spouse. And the common answer given is that she is not capable of looking after the property. As I said, that's a different proposition altogether. There is also something known as life interest. How does this work? You can give your property to your children, but in the will, you have a right to state that my wife during her lifetime will have an unconditional right to reside in this property, to stay in this property, to rent out the property, to collect rents on the property, and also lay down a further condition that the children to whom you have given this property shall not dispose of this property or mortgage the property or create any form of encumbrance on the property during her lifetime. Now, when you do this, you have at least provided for the safety and welfare of your spouse. While the property has actually gone to your children or to whomever you may want to give it to, but it has the concept of life interest is during the lifetime of the spouse, this property shall be preserved without creating any encumbrance on it. That is a safeguard. And alternately, you can give a direction that you sell the property and distribute the proceeds amongst anybody you want. That is the simplest thing to do, particularly when now in a large number of cases where children are residing in America, they have become American citizens, they have become citizens of other jurisdictions. They may not want to hold Benami properties here because they have to now globally declare all their properties, irrespective of which country you're in. Therefore, it may make eminent sense for you to say, sell the property. And now that capital assets can be repatriated, you can say sell the property and distribute it in percentages to whomever you want. Now, you can give your immovable property to charity. You can give the whole house or your property to charity, with or without life interest to the surviving spouse. You can give it away to a caregiver. There have been instances where the entire family has deserted the senior citizen or an older person, and therefore that person has given away the property to the caregiver. You can give it to anybody you want, grandchildren, nephews, nieces, in differing proportions. But the moment you give it in proportions, I've explained the problem to you. You can also create a trust under a will for your family, for your dependents, or for specially challenged family members. Now, a trust can be created in two ways. You can create a trust outside of the will. In other words, you can create a trust now. This is known as a private trust. You can create that document now and understand, identify trustees who will administer the trust, identify the objects of the trust, and so on, which means it is for the benefit of family members. These are known as private family trusts. These are taxable entities, and you will pay tax on that income. But you can also create a trust under your will. You can say that all my properties will go to this trust that is created, and this trust will look after so and so, so and so, so and so. Look after my children, look after the marriage, the education, the health, so on and so forth. That is also permissible under a will. And insofar as movable assets are concerned, a person who is entitled to receive immovable property is entitled to any movable property. There is no distinction. Any person you want to give immovable property to can also be given movable property. Now, some of the common queries that are asked before I get to the questions. Can liabilities be bequeathed? In other words, can you say that my son shall repay all the liabilities? Yes, you can, but he cannot be forced to do that because a will is a beneficial document. It is not a liability document. But you can say that I am leaving this house to my son, provided he pays the bank this amount of money. That can be done. It's contingent. It is your direction. Next question, should the family be involved in making a will? Our answer is no. Why? Because you have a family get together and you discuss who is going to get which house and who is going to get what property. You have laid the foundation for future disputes. As far as possible, please remember that it is your property. You have an unconditional right to dispose it off in the manner you wish to. And unless the family relationships are so excellent and so hunky-dory, any kind of discussion which results in the children knowing which property is going to whom is likely to create a problem in the future. It also is likely to create a problem inter se the brothers and sisters or siblings, because their family relationships get affected because they know who is getting the larger share of the property and who is not getting the share of the property. Next question that is usually asked is a will a public document? No. If you register a document, nobody else is entitled to get a copy, certified copy of the document, unless the members of the family are able to prove to the sub-registrar that the person has actually died and that this person is a member of the family. Now, this problem arises in high net worth individuals because most of them are very apprehensive that a will is like a sale deed or any other public document. Any member of the public can apply for getting a certified copy, but that is not true. There is a separate document register that is maintained in the registrar's offices relating to wills, and their confidentiality is completely preserved. There need not be any kind of worry on that at all. Next, where should the will be kept? Obviously, keep it in a place where somebody knows where it is. Now, you keep it in a locker, in your bank locker, and you die. Nobody knows where the key is. And it's a locker in your single name. So nobody can open that locker because it's in your name. Therefore, make it even a bank locker. Try and make it in the either or survivor mode where both can operate. And tell somebody responsible in your family that the will is here. There are people who have slept with the will under their pillows for years together. But that's not really the answer. The answer is put it somewhere where it is accessible to somebody. Please remember that as long as you are alive, the will is dead. It doesn't matter where you keep it. Even if a person gets hold of that document, he can do nothing with that document because it creates no rights in the property. Can a mortgaged property be bequeathed? Yes, it certainly can be bequeathed. But the person to whom you have mortgaged the property can recover the amounts due only from the property and not personally against the legal heirs that you have left behind. Should copies of the will be made? The answer is no, absolute no. Because in today's technology, signatures can be forged, documents can be forged. Therefore, not even an unsigned copy should be made. Only one original should be available. Should a copy of the will be given to family members? My answer as an advocate is no, do not. Because that is when you are creating a conflict situation where persons know what you've done and what you've not done. Now, this is where I will stop for the moment and let's take questions that have come. The first question that has been asked is, both my wife and I have made our wills around 3 months back, duly witnessed and with endorsement by registered medical practitioners about our being physically and mentally fit. However, we have not registered these wills. I have 2 daughters. We have bequeathed equally to both of them and have also shared this information with them. Both of them are well off, one being an American and the citizen. I do not expect complications from their side post our deaths. That answers the question. You do not expect it. Where is the guarantee? Therefore, if you want a guarantee that there will be no fights and arguments and quarrels between siblings, please do register a will. That is the first question that's being asked. Is it necessary to register the will? It is not compulsory, but it is advisable, because if one is in a foreign jurisdiction like the US, then when they declare the property as belonging to them, she or he will have to produce a copy of the will to the American authorities. And if it's an unregistered document, it has its own complications insofar as the American law is concerned. Can these wills be registered now? Yes. There is no limitation or there is no time limit within which the will can be registered. It certainly can be registered. In fact, my advice is please do register the will. Second set of questions, transferring ancestral property, which would be a better option through registered gift deed or through a will? That's a choice you would make. If you transfer it through a gift deed, the transfer will happen now, immediately, and you will cease to be owner of the property. Whereas if you do it under a will, it will happen only after your death. Can someone make a will saying that one can enjoy the property fully, but if he decides to sell, he has to get the concurrence of his brother? Technically can be done, but my question is, why would you do that? What do you achieve by it? You're only creating more problems. This again, please remember, if you want to leave a legacy behind and not litigation and problems behind, this is the first situation where you will create problems. It can technically be done, but certainly not admissible. These days, many agencies, including banks, advise formation of trust. I have already advised you on what can be done as a trust. If the wife is a partner in an HUF along with the brothers in a parent's ancestral property, in case of her demise, what happens to the share of a property? It will go according to the law of succession applicable. Today, the Supreme Court has laid down that the daughters are also equal co-partners in HUF property, and therefore it will go according to the law of succession. Will it be advisable to form a separate trust for charity purposes, mainly for providing financial assistance to education of poor, etc.? That's a choice you make. If you want to create a trust today, essentially for charitable purposes, you are free to do so, nothing wrong in it. And if you want some portion of your assets to be bequeathed to this trust under your will, that is also permissible. So you have two separate entities. One is a private trust or a public trust, which is looking after education and poor feeding and so on. Under your will, you can either donate a specified sum of money to the trust or give immovable property to the trust. No problem at all. Then you have another set of questions. Since one doesn't know which spouse goes first, what is the mechanism? I have told you it's a mutual will and simultaneous death have already been covered. If all your investments, not real estate, have a nominee designated, there is need to bring the passing also. This also I have tell you what is the status of a nominee. He holds it in trust, but all other heirs have a right unless you have made a specific will giving away that property to someone in particular. Is there a will need to register the will? That has also been open. What happens if there is no will? We have told you that it will be intestate succession. If you are an author and managing trustee of a charitable organization, not-for-profit entity, is there any need or advantage to bring that into a will? I have not quite understood this question. Suppose you have created a trust or you're a managing trustee. You cannot will away that position to somebody else. That is not permissible. A trust is personal. It is related to the person by name. A trust is what we call a fiduciary relationship. It's a relationship of trust. And because I have trust in one person, I appoint that person as a trustee. But that does not become a heritable office. You can't say that I will my right, I bequeath my right to be a trustee to so-and-so. But you can do that in a private trust, in a private family trust, not in a charitable organization or not-for-profit entity. They are not heritable offices. These are the questions that I have received. Now the floor is yours. Raghav, the mic is back with you.
Yeah, I'm not sure. I got a couple of questions on the chat, but I think they've all been dealt with in what you have said. But sure, I can see everybody on the screen since you're just 25. Anybody who still has a question? I saw Pushy raising his hand somewhere in between. Pushy, why don't you unmute yourself and...
Yeah, Mr. Vinod Sharma has also raised his hand. Mr. Vinod Sharma.
Yeah. So, Pushy, you just start by unmuting yourself and speaking. Then Vinod Sharma.
There was a slide on movable assets. It was very quickly removed. If you can.
Sorry, who's speaking?
Towards the end. Movable assets.
Okay. I cannot hear the.
I don't know who spoke. I was asking Pushy to speak for the moment. Just
Can I speak?
and
Can you
then
hear me?
we'll go on to the next person quickly. Pushi, go ahead.
Can you hear me?
Yeah.
Yes, I
very
can,
good.
but I can't see you. It means who is pushing. Okay.
Doesn't matter. Yeah.
Okay. Yes. Go ahead. Please go ahead.
Okay.
I'll spotlight.
My question is that if you have only one child, then is it necessary to make a will? Like, I mean, all the property would automatically go to that person.
It is not related to the number of children you have. Now, as I said, suppose you have one house and you have only one child. You also have your wife. You may have your mother.
Yeah.
But if it is only one surviving heir that is your child,
Yeah.
you technically need not make a will. But if he goes to the corporation and wants the khata transferred to his name, then they will ask for a will.
Okay.
Or they will ask for what is commonly known as a Vamsha Vriksha or a family tree. They will want you to go to the Tahsildar's office and go through the government process of securing what they call a official family tree. It'll be impossible for you to do that, because how will you prove that this is the only family and that there are no other family members?
Okay.
Therefore, whatever be the circumstances, it does not matter. There is no great problem involved in making a will. It takes half a day, and it is even more easy if you have only one son.
The other question is, if the person is a foreign citizen, like my daughter is an Austrian citizen, will that any complications in making a will? Do I have to make two separate wills in Austria and one in India?
If you have property in multiple jurisdictions, let's say you have property in Australia or UK and wherever, please make separate wills for assets outside India.
Okay.
Because the law in US is different, the law in UK is different, and they will probably not accept the kind of wills that we make. There is a separate process of registration in US, for example. They have a county registration facility. So please distribute it, make separate wills for each asset.
Thank you very much.
I think that's particularly important advice for many people who do have children abroad and who may have properties abroad. Yeah, I think Vinod Sharma, you had a question?
Yeah, I have one question. What is the cost of registering a will? Is it a percentage of the asset value, or what is it?
No. The will can be on plain paper.
Okay.
It need not even be on stamp paper.
Yeah.
The registration cost will be about 1,000 rupees.
Oh, that's all. Independent value.
No, it's not ad valorem. It is not on the value of the property.
Oh, okay.
This excludes the sub-registrar's bribe and the lawyer's fee.
Yeah. Okay.
Those are.
Yeah. Right. Thanks.
Oh, you're welcome.
Anybody else? Suresh, go ahead. Unmute yourself and yeah.
Is it necessary to get a succession certificate, even under the will?
Let me clarify this. A succession certificate applies only to securities and movables. It is not relatable to immovable property. If you want to relate it to immovable property, then it is probate. Succession certificate is a certificate issued by a court authorizing you to collect the debts and the amounts due to you on the date of your death. Now, if you have a will in respect of that, a registered will, a succession certificate is not necessary. But if you have an unregistered will, it is possible that all the financial institutions will ask you to get a succession certificate. Their apprehension is that there could be other heirs claiming a right in this property, and therefore they would want a succession certificate. This is a very simple case of what you management guys teach us. Cover your backside syndrome. You don't expose yourself to liability. That's what the banks and financial institutions say. I'll give you the money, get a court order. Therefore, make a will, and that's it. You're absolutely perfect. No issues.
Thank you.
Yep. Any other hands getting raised or questions to be asked?
Yes, yes. Very lucid. Thank you very much.
Thank you.
unmute everybody and join me. I think it was a super.
Thank you.
If I say so myself, the range of things it covered in a short time. I was writing down one or two questions which I had, and before the end, of course, they were not relevant, like where to place the will, but that was covered. So thanks so much, Shiv. I'm sure that a lot of us will benefit from this advice, and those of us who have not made a will get down to making it immediately and registering it. And I'm particularly happy that you talked of the subject of bequests. Nobody in this audience will be surprised if I remind you that there is a fund called the Class Gift, which is available for us to donate to our alma mater, the Indian Institute of Management, Ahmedabad, for which I've been pushing repeatedly. So if you don't want to give it now, put it in your will, and one day it will go to the institution from which we got so much. So excellent. Let me get back to thanking you, and really it was delightful to hear everything again from you, Shiv.
Thank you. Thank you for this opportunity. It's been a great experience. Thank you so much.